Bună ziua, dragi urmăritori! Sunt Dumitru Ovidiu Ioan, decanul Facultății de Drept din cadrul Academiei Studii Economice din București și vă urez bun venit la prima ediție BusinessLawTalks, un podcast pe care îl lansăm cu ocazia înființării celui mai nou centru de cercetare din cadrul facultății noastre, Centrul de Dreptului European al Afacerilor, un proiect al facultății noastre, acestui centru și al Asociației Române de Drept Afaceri, partenerul nostru instituțional în multe proiecte și activități pe care le derulăm în cadrul Facultății de Drept. Acest podcast vine să înlocuiască un proiect pe care acum câțiva ani de zile l-am lansat la nivelul facultății, Drept ASE webinars, și care a fost destinat dezbaterilor între profesioniști, între cadre didactice, profesioniști și chiar studenți. În acel moment noi am pornit la drum pentru că eram în pandemie și doream să aducem aproape de studenții noștri și colegii noștri practicieni, reputați profesioniști din lumea dreptului. Acum, pentru că suntem în alte condiții și de asemenea dorim să lansăm un proiect ceva mai dinamic, am considerat că un podcast video ar fi util pentru colegii noștri, studenții noștri, urmăritorii noștri din social media, dar și de pe canalul YouTube. Acest podcast va fi în principal urmărit pe canalul YouTube al Facultății de Drept și canalele social media. Formatul acesta presupune un coleg al nostru de la Facultatea de Drept, în calitate de gazdă, și un invitat străin sau român, a cărui expertiză și, desigur, specializare îl face să fie extrem de util și necesar acestor dezbateri. Prima ediție începe cu un invitat străin, așa că se va desfășura în limba engleză. Eu sunt prezent aici pentru a face introducerile și pentru a preda colegului meu care preia această dezbatere. Sper ca acest proiect să fie unul de succes, sper să ne urmăriți de fiecare dată. În cazul în care aveți pe viitor întrebări de adresat, în momentul în care vom lăsa invitația de podcast sau vom anunța speakerul, vă rugăm adresa aceste întrebări pe YouTube sau pe canalele de social media, astfel încât și noi să putem, în cadrul respectivului podcast, să îi le adresăm invitatului nostru. I'll switch now to English. And I want to welcome the followers, I want to welcome our students, our colleagues, and all the other professionals in the field of business law. This podcast is a new project of the Faculty of Law within the Bucharest University of Economic Studies. It is coming to replace a project that we launched in the pandemic, which was called Drept ASE webinars. And now, because we speak about other conditions and we grown up, we consider that we can actually have a podcast, a video one. But the format remains similar in the idea that we'll have an expert, a renowned expert, as a guest of our faculty. The format will be with one of our colleagues, me or somebody else from the department, in front of you with the special guest invited for that special edition. And here, the one next to me representing our faculty is our visiting professor, Dan Pascu, Vice President of the Competition Council, and for the last years, the one coordinating the activity at competition law and European competition law subjects. As a special guest today, I'm also a visiting professor at our faculty. We have our guest, Steffen Hindelang, renowned professor at Uppsala University, executive director at CELIS, international arbitrator at ICSID, and consultant for business organizations, but also state organizations and NGOs. I want to welcome Steffen for these days here in Bucharest as a visiting professor of our faculty, but of course our first special guest at BusinessLawTalks. Hopefully we'll have an interesting debate today, and see you, dear followers, also for the next podcast.
Dear Steffen, nice to have you in Bucharest at our first episode of the Business Law Talks of the legal faculty, of our legal faculty. We have two state faculties, legal faculties in Bucharest. This is within the Academy of Economic Studies, our legal faculty. We are going to talk about the foreign direct investment screening. I'm going to make a brief introduction, and then we're going to pursue with questions in the area where you're a real specialist. So 5 years ago, the EU adopted the FDI, Foreign Direct Investment Regulation, as a key trade measure to address an increasingly complex geopolitical stage. Since it became applicable in 2020, the number of FDI regimes in place in Europe has almost doubled from 14 to 24, leading to an aggregate screening of over 4,000 transactions by the European Commission and the member states' authorities. The EU's FDI regulation was adopted in order to identify and to address risks that foreign investments could pose for security or public order in the European Union member states. Today, the vast majority of the EU member states have put in place an FDI screening mechanism. FDI proceedings play their role in ensuring that specific transactions will not affect the public interest as defined by national authorities of the member states. So my first question would be, how does the FDI screening mechanism work in practice, and what role do member states play in the process?
Dan, first of all, thanks very much for the warm welcome. I'm delighted to be here at the Academy of Economic Studies and its Faculty of Law, and I'm very impressed by the initiative you have been taking here together with your colleagues. I think this is very applaudable, and I'm happy to be the first one able to contribute. When it comes to investment screening, I think in your introductory remarks, you already pointed towards the timeline. It's a quite recent phenomenon which we are facing in the European Union for a long while. There was a firm belief that investment, irrespective of its origin, is welcome, is leading to growth and general welfare, and this has also, at least in economic theory, not changed, but our geoeconomic landscape has very much though, and I think we are not here to speculate about the reasons, but one thing I think is key, that in particular the United States has shifted from a very open approach. There are famous speeches of George W. Bush welcoming any investment, and no investment should be discriminated, to Trump during his first presidency that investments can actually endanger national security. And the conflict here is between China and the United States. And one has basically shifted from a liberal economy approach to a more, let's say, realist approach. And in that context, the European Union had to react and position itself. Europe is very much outward looking, and the welfare of most of the EU member states is very much dependent on open markets. But of course there are sizable security risks, and that had to be addressed. Across the continent, the perception and the need for an investment screening mechanism has been, let's say, quite different. Not each and every member state has been from the beginning very much convinced of the idea. There are member states like France, which has traditionally have a system which screens for an investment, has been in various troubles with the European Commission because in the past this screening mechanism was used for protective purposes. Then there are countries like Sweden, for example, or also most of Central Eastern Europe, which has not had any kind of screening mechanism. Quite to the contrary, any investment has been very much welcomed. In this political landscape, the Commission had to put forward a policy initiative, which was basically asked for by France, Germany, and Italy. They wanted to have something in place, and here you need to have a balance, and you asked for the role of the member states and the Commission between basically guarding national security, or in a broader sense, public order and security, which very much member states believe it's their own domain. Of course, having a level playing field across the internal market, so that not basically you can enter the internal market through a back door with some member state running a super liberal system, another quite a restrictive one. And here the compromise was what we call the EU screening regulation, which is a quite peculiar animal, because what it does, it is not harmonizing the member states' screening mechanisms. The Commission, in its policy initiative and then later in the legislative act, put forward simply recommendations for investment screening, and on the one hand, and on the other, it created a cooperation mechanism in which the member states can actually securely and safely exchange information on potential threats to public order and security for other member states, but also for the Union as a whole. So the role of the member states are still firmly in the driving seat. The member states are allowed to basically enact screening mechanisms to protect public order and security, and are only mandated, obliged to follow basically the directions within the coordination mechanism, which is very much from a market perspective in the background. So you're not, as an investor, getting in touch with the screening mechanism directly.
It was a very detailed answer. And if you allow me, I dare you to brainstorm a little bit with me on this topic. There are recommendations in this regulation. I've just told you my opinion. It's kind of a hybrid instrument. It's not quite a regulation because it has to be implemented in the national law systems by some sort of national act whatsoever, which brings the regulation near the directive. Mm-hmm. But still it is a regulation. What's your opinion about this form, the form European Union, the European Union chose to implement this security screening?
That's a very interesting question for especially EU law experts, and I think it's also a pertinent one. I wonder whether at some point that is actually ending up before the Court of Justice of the European Union, because first of all, we need to know that the screening regulation was enacted on the basis of a competence within the area of the common commercial policy. And common commercial policy is an exclusive competence of the European Union. That means the member states are barred from acting irrespective of whether the European Union has acted in the field or not. So that's the situation. Hence, if the European Union were serious about, they could, of course, fully harmonize and create a complete screening mechanism on the European level with certain exceptions. I'll come to this in a moment. But for that, the European Union, of course, needs a majority in the Council and in the European Parliament. When you look at the EU treaties, you have a provision in Article 4, Section 2 of the TEU, Treaty on European Union, which speaks of national security being the prerogative of the member states. However, this is not a domain réservé or anything like that. It is basically only a limitation to the European competence within the area of the common commercial policy. And then there are certain aspects also reserved for the member states when it comes to armament and defense.
Yes.
But in that area, actually the European Union can act if they get the sufficient majority. So, but there was no compromise among the EU member states to actually establish a European screening mechanism, because the understanding of what is subject to public order and security, how restrictive a mechanism shall be, is greatly varying. So when you also see Sweden, for example, we have a little bit of an insight. At the beginning, they were very much against a screening mechanism and shifted dramatically, but probably also there was an intense process of convincing which happened there. And when you look now why a regulation was chosen, it essentially relates to the cooperation mechanism. So that's the very purpose of why we're having a regulation mechanism, because you need to oblige the member states to collaborate among each other as well as with the Commission. That's not really possible with a directive. But everything else is very peculiar, because a regulation, when it comes to the mechanism, screening mechanism is not containing any obligation to introduce one. Only if you introduce one, you have to basically to follow basic standards of the rule of law. But for that, actually, you have not had the need for a regulation. You should have just relied on the EU treaties. I mean, that's anyways an obligation to act transparent, to provide for legal redress, and so forth.
And in respect to this cooperation mechanism, it is indeed very important, because on ground, on this legal basis, member states authorities can exchange information, classified information, with the European Commission and within member states, between member states authorities, something like in the European Competition Network. Mm-hmm. It's kind of related. Steffen, what challenges have emerged in implementing the regulation, both in the European Union and, if you have any information, maybe on the level of the EU member states?
Mm-hmm, mm-hmm. I mean, there have been various challenges. I mean, right now, I think from the European Union priority, as I understand it, is to have a screening mechanism in each and every member state. And there are still resistant parts of the Union which struggle to introduce a screening mechanism. Others have a screening mechanism in place for many years, but it's a very narrow, a very, let's say, old-fashioned screening mechanism.
Also the case of Germany. Excuse me for interrupting.
Germany,
you had some sort of screening mechanism.
Has had since the 60s, something like a screening mechanism in the Foreign Trade Act.
Old school Cold War
legislation. They could, and there was like two general clauses. One of which basically related to national security of the Federal Republic, and the other one to actions of foreign nations against the Federal Republic. So very classic provisions. But screening in Germany came in basically slowly and gradually. In 1988, it was basically the US moving to a more formalized screening mechanism. And then in the aftermath, Germany also introduced a very small one, nascent one, only relating to the military area, and then it continued. Today we have a very far-reaching mechanism, which sits not very easily with our liberal approach to regulating the economy. But no, it's in Europe's southwest, for example, there are member states which have also had a screening mechanism of this nascent nature and have just not changed anything. So they are actually facing challenges to basically screen if you take the criteria in the screening regulation, which are recommendations on that same spectrum. The Germans, as many other EU member states, have fully implemented, sometimes even further than what the screening regulation says, measures. They've also reduced the thresholds. Before the screening regulation, you need to have a real and serious threat to public order and security. Now you need to have only a certain degree of likelihood. So thresholds have changed dramatically.
Can you think about, or can you share any high-profile cases where the FTA regulation, the EU FTA regulation, was a critical factor in approving or blocking a certain investment?
It's the true answer is actually the EU screening regulation is not really relevant in that context, because it's the member states which are in the driving seat, right?
Yeah.
And there are, of course, a number of high-profile transactions. I mean, from a German perspective, it has been the Hamburg port, or a part of the Hamburg port, actually a terminal, which was sold to COSCO, a Chinese shipping company, and which was ultimately with certain conditions cleared. But interestingly, at the same time, two Chinese businesses wanted to acquire mid-sized German businesses in the chip sector, which was basically essentially more or less at the same day blocked. That, of course, also causes questions. Is that maybe a political deal which was made here? So you see already, it might be a mere coincidence, but time-wise suggests differently. Maybe it was bad timing. But when you asked me earlier with regards to challenges, because every member state operates essentially against its own security background and also economic needs and economic relations. Germany is very much integrated, and also China is very much integrated with the world economy, and China is an important market. So you would probably expect that this informs decisions of the authorities. And this is the biggest threat, actually, which is posed, that this EU screening regulation actually encourages member states to introduce mechanisms which are operated against a national background and not against an EU background. So each member state now basically regulates access to the internal market as they deem fit. And that may prove problematic in the long term.
I can think about this other case in Spain, where the national authority blocked the takeover of train factory, train giant whatsoever by an Hungarian undertaking on grounds of the FDI regulation, claiming that the Hungarian undertaking was closely connected to some Russian interests.
That is what has been reported on the press. We don't know. The point is, courts should be able to review these kind of questions in order to actually review of whether this is just something which is made up or it's real. So what is necessary, I think, within the screening regulation and its development, that we are making sure that actually there's legal accountability. And this is a challenge in the area of trade and investment with third countries. Traditionally, administrations enjoy greater leeway. A lot of questions relating to national security are in some jurisdictions not reviewable at all. And here, I wonder where investors are left when essentially they are operating against the black box. And here we need to work hard on all levels, the legislator, but also, for example, academia, private practice, businesses, to create a mechanism which does not create too much red tape. So we need to have a transparent mechanism. I think Romania publishes its decisions. I think that's best practice, something which not just Romania should do, similarly to what competition authorities actually do in order to provide guidance. That is extremely useful. Also, we need to talk about different thresholds, which sectors are relevant, can we find a rough consensus across the European Union, not that suddenly clay and sand pits in certain member states are a matter of national security. We need to have these discussions.
I'm going to get back to this, to your last observation, but as you have mentioned courts, I was thinking about Article 6 of the European Convention of Human Rights and the publicity of the trials. Mm-hmm. How can a decision, a prohibition, a blocking decision be revised by a court that would suppose that a member state of the European Union reveals its own national security vulnerabilities? In this framework, the public trial, according to European Convention of Human Rights, and the correspondent right in, I suppose, every constitution in the European Union.
Yeah, I think the questions the court needs to address and the challenges posed for the court are not significantly different from export control, where also questions of national security play a vital role. And when you look at the procedural law, at least of my country, I can speak of a little bit more in details. We have in-camera hearings for this kind of situation. So if you want, as a court, really go into the details, you have all the options. You can have a witness from the intelligence services basically questioned as a judge in camera, and so hence national security is preserved, while nonetheless the investor has a chance to actually review these decisions. Just courts need to be more assertive of these kind of procedural instruments. That's a challenge also, which we see in export control. Courts are hardly using it. And the more so we operate with national security lacunae, I think the more courts should actually step in and fulfill their role to review government where need be.
Steffen, could you please draw some comparison between our European FDI screening system and the screening system of our main trade partner, the United States of America?
I think it's not comparable at the current state. Yeah. So what you can do, you may be able to compare on a national level, and some member states, Romania, among each other, have certain resemblances to the United States. But older systems, like take the German system or the French system, have little to none resemblance. Yeah. So from a European perspective, I mean, since we are somewhere between a intergovernmental organization and a federal union, this is difficult to say where things are developing. What I see in the long run is that the Commission is more and more asserting itself as somebody basically presiding over screening processes which have a European dimension. And the proposal for the revision of the EU screening regulation, you also see already a stronger role of the European Commission when it comes to the interest of Europe in these kind of screening processes. And I think it's also very important because it is quite common that you have multi-jurisdictional screenings, because you might have interests of the targets across the union, and so you have several member states screening, and here you need some way of coordinating.
Have you any picture about the FDI regulation could evolve in the next years to address new challenges or to improve its effectiveness?
Yeah, I think there's a lot on the horizon. I mean, the Commission has proposed an update where, for the first time, member states is going to be obliged to have a screening mechanism with certain minimum criteria. So that's actually more what we think about of a regulation, but still a bit at the edge towards the directive. So everyone, also those currently still resisting, need to have a screening mechanism. The true innovation, in my view, you see in the cooperation mechanism, where the member states will have a way stronger obligation than they have currently to justify themselves when they deviate from an opinion voiced by the Commission on a certain transaction. So here we'll see, I think, a slow process of harmonization, not in the classical sense that we are going to have full harmonization, an European screening mechanism with the Commission screening. That's, I think, more on a long-term project. But when it comes to coordination, the Commission is basically using this classical compound administrative procedures, which we see in so many areas in Europe, with the view to basically assert the European interest. Just one last point, maybe. I hear that early next year the Commission is also tabling its ideas, or is basically the results of its review process for need of a outbound investment screening mechanism. It's a very interesting topic. I'm looking forward to that assessment. That's one point, and a point which the Commission actually needs to address outside investment screening is how he can make sure that this investment screening is not severely jeopardizing the internal market. I mean, as we see with regards to a Hungarian undertaking trying to buy a Spanish undertaking. Yeah? And there are many more examples of that. Yeah? And when you look at large corporations in Europe, how often do they have a third country shareholder? Yeah? Whenever you basically assert there might be a third country interest justifying screening, you can basically screen almost any trans-border investment. And here I see the biggest problem.
You have mentioned fragmentation of the internal market insofar that we have 27 entering gates of investments on the single market due to the fact that national authorities on national rules are allowing or blocking certain investments in the European Union. And then you mentioned harmonization in this respect. It's obviously that the FDI regulation failed to introduce common substantive rules and criteria to structure these mechanisms, leading to fragmentation. How does this impact the European single market? And the second question related to that, does FDI screening pose a threat to the single European market?
I think to the first part of your question, having different criteria for each member state, which vary greatly. There's a huge variety and creativity among the EU member states, what they would like to screen and what they would not like to screen. It leads to additional costs when you invest in the European Union, because you have to file in several member states. Member states have different timelines. They have different government priorities when it comes to reviewing these investments. Some are very much pro-investments, others are seeing that more skeptical or have a second thought. So I think managing these kind of cross-border M&A processes has gained a little bit of more complexity, which is great for the legal profession, but I'm not sure it is so great for investors. And second point is fragmentation of the internal market is what we're doing with intra-EU investments. That's still a huge amount of our transactions in the internal market. We should not underestimate that. And here, so far, the rule was you're not piercing the corporate veil. If it is a member state established legal entity, it's basically a passport to travel across the internal market. This has now been explicitly, and there are not so many examples in EU law, basically pierced by the proposal of the European Commission on the new screening regulation. Interestingly also, we see already member states screening intra-EU investment despite having not any competence. I mean, the Court of Justice clearly said in the Excella judgment, the EU screening regulation does not apply to intra-EU investment. Yeah? So they cannot refer to the screening regulation. They might do still under the fundamental freedoms. That's fine. So, but for that, the threshold might be a different one. But that's also more an EU law nerd question, whether there are different thresholds or not. No. We're not going to bother our audience with that today.
I think the European Union, and I'm speaking about the European Commission, is considering to screen also intra-EU investments. Is there any magic formula to balance the protection of national security and public order with the need of an open and investor-friendly market in Europe?
I think it's going to be one of the biggest challenges we are facing here. My view is that there's not one magic formula, but a series of measures one can take towards preservation of a level playing field within the internal market. I think a key is transparency and predictability. I think here I mentioned that already earlier, Romania is doing really a great job by publishing these decisions. This is a role model. Another way is improving legal reviewability. Here the challenge is going to be, even if you have the perfect review mechanism in place, the interest of the market participants. So if are they really interested in challenging the decisions, or are they just moving on? Because they're simply finding other interesting targets. Question is whether these other interesting targets are within the European Union. That is something which our economists are going to tell us, whether we are actually not making our union less attractive. And maybe a last point is, indeed, we need to face it, creating common standards for investment screening, which are basically applicable across the continent. That would probably prevent most of the potentials for abuse, or more potential, not most.
It's a very delicate balance indeed, because if you think it's also in the national interests of member states to absorb as much investment as possible, through the lens of economic growth, of jobs and GDP growth, etc. Would you have any advice for businesses, foreign investors, member states navigating the complexities of the FDI regulation?
I think I'm not in a position to give member states, commission or anyone advice. I can only speak for myself here. And what I think is very important, that all the stakeholders around are very carefully monitoring that process. That means not leaving it to specialized attorneys and government only. Businesses need to play a decisive role as basically the users of these mechanisms, and also highlight when mechanisms get out of proportion. I think a diligent businessman is easily understanding the need for national security. But of course, we need to also be able to point towards protectionist tendencies in some member states. So I guess here that would be my advice to the business community to actually closely monitor that and point out when processes basically are straying off the actual goal.
With respect to this protectionist tendencies of member states, do you have something particular in mind, or was it a general concern of yours?
I don't want to point fingers.
It's a pity. We should gossip a little bit.
Gossip
on a high level, high academic level.
Yeah. I mean, what you see, for example, is that's very interesting that the information you exchange in the European cooperation mechanism is in some member states straight passed on to their businesses. So that's actually not supposed to be the case. So what we're going to do with these kind of basically special help for domestic industry? Well, that's, I think, something we need to talk about. But what I think is we need to have fora, like for example the Sellers Institute, where basically we are coming together, thought leaders in this area, to talk about the strategy behind this instrument. We need to have a plan. We cannot just all build mechanisms and not having a clear goal. We need to have an understanding as Europeans on the goals we are pursuing here together. Otherwise, I feel all measures basically relying on these opaque terms and concepts like national security, public order and security may actually be a threat for the internal market.
You mentioned the Sellers Institute. Would you describe your institute in a few sentences, promote the institute, make a little bit of advertising, please, for our audience today?
Happy to do that. The Sellers Institute is a non-profit, non-partisan initiative from basically everyone involved in the area of investment screening and economic security. Our idea is here really bringing together thought leaders, government, private practice, businesses and academia, and developing basically ideas for Europe, pointing towards strategic initiatives, exchanging thoughts of best practice, developing long-term plans for how Europe in the end can balance national security or public order and security, competitiveness and open markets. I think our economy is too important to run it without a strategic vision.
If you were to predict the next major shift in the EU's approach to FDI, what would it be?
I think we are going to look at outbound. It's a lot of questions have to be answered. I'm very much looking forward to the Commission's case on that point. Do we have the need? If there's a need for addressing outbound investment, so maybe just also jumping quickly back, why outbound investment? So the United States has recently enacted a mechanism because they fear that both capital as well as know-how is allocated towards certain countries, which may then use it against the United States and their national security interests. And the American financial markets is very deep. The know-how in that regard, which you find in the United States, is broad. Coming to Europe, we have still not basically concluded the capital markets union, which have been driving for a while this process, but still we have a number of regional stock exchanges. We have not really an integrated capital market in the European Union, so which leads to a number of conclusions. So do we have actually the right players, which are the addressees of this kind of regulations? Do we have funds? And also basically people working in the industry to that extent that it warrants a legislation for one, or if we do have this threat situation, can we not address it with already existing instruments like export control is an interesting instrument here, which also addresses know-how exports. And from that perspective, I think a lot of questions have to be answered. I'm also looking forward towards the United States, basically presenting first case studies on how they operate the mechanism, so that actually there's evidence, hard evidence out there that we need this in order basically to protect our interests.
Steffen, thank you for your insightful ideas. Thank you for being in Bucharest. See you next time.
Great pleasure. Thank you so much.
And thank you all for watching the first episode of the Business Law Talks, forum of scholars and practitioners dedicated to students, scholars and practitioners interested in the different areas of Romanian and international business law. Thank you.